Take a little trip with me, I'm gonna take you home.
Take a little history down this lane of memories.
Down this lane.
So let's raise another glass for the glorious past and the friends we have become. Yeah, 'cause little did we know the good times come and go, but the best is yet to come.
Hello and welcome to a special interview for The Wire. Earlier this week, the lawyer Prashant Bhushan wrote an article for The Wire which is a critique of the Supreme Court's functioning during the lockdown. Prashant Bhushan makes three critical points. He claims that the Supreme Court is not doing enough to defend the constitutional rights of the Indian people, particularly the poor and vulnerable. Secondly, he questions the prioritization on which the Supreme Court is choosing to hear some cases immediately and to postpone others perhaps even indefinitely. And thirdly, Prashant Bhushan says that the Supreme Court has surrendered its power of judicial review over government policy and action. With me to discuss the functioning of the court is one of its most learned and highly regarded former judges, Justice Madan Lokur. Justice Lokur, as I said in that introduction, Prashant Bhushan makes three key criticisms of the court. And very briefly, they are a claim that the Supreme Court is not defending the constitutional rights of the Indian people, particularly the poor and vulnerable. Secondly, he questions the prioritization on which the court is hearing cases or deferring them. And thirdly, he says that the court has surrendered its power of judicial review over government policy and action. I'll come to specifics later, but broadly speaking, do you agree or do you disagree with Prashant Bhushan's criticism?
Yeah, thank you, Karan, for inviting me on your show. It's a pleasure being here. Well, as far as the critique by Prashant is concerned, I have gone through it. Broadly, yes, I agree with him, but I think he has been a little uncharitable in the sense that when we discuss about judicial review, I'm not sure whether the use of the word surrender would be appropriate. But yes, broadly, I agree with what he says.
Let's then go through his main criticisms one by one, and I'll come to judicial review right at the end. To start with, let's talk about the way the court has responded to the right to life of migrant workers. These are people who are destitute and starving, they're desperate. We've seen on television how hundreds of thousands, if not millions, tried to walk back to their villages. Now, a petition on their plight was filed in the Supreme Court on the 31st of March. Thereafter, for one reason or another, the government was given additional time and new hearings were scheduled. Finally, 3 weeks later, on the 21st of April, the court disposed of the petition with a pretty anodyne and tepid request to the government to take such steps as it finds to fit to resolve the issues raised in the petition. Do you believe this is an acceptable way of responding to the right to life of Indians?
You see, it's like this. I think the concept of public interest litigation in this situation has been completely misunderstood. The purpose of public interest litigation is not adversarial, right? There is a problem which the public interest petitioner brings to the court, and the government or the state, whoever it is, if it's a state government or if it's a central government, says that yes, perhaps things are not as they should be. They can improve, and we'll certainly try and help you out. And the court works in that direction along with the public interest petitioner and the government, and arrives at a solution. Now, in this particular case about the migrants, the stand that was taken was adversarial. There's nothing wrong. We are doing everything that's possible. There's nothing wrong, and so therefore, please don't interfere. I think that stand probably, resulted in what has happened. There was a problem. I think the government should have acknowledged that there was a problem and should have tried to find out ways and means to remedy that problem with the assistance of the court, if it is possible, or even otherwise. I think that's where the mistake was made. And yes, I think in that sense, the court let down these migrants, certainly.
When you say the court let down these migrants, are you saying that the court should have put more pressure on the government, should have been more clear cut that the government must act rather than simply say, and I'm quoting the court, take such steps as it finds fit to resolve the issues raised in the petition?
Yeah, you see, the thing is that these migrants don't know what the steps that have been taken, you know. So to say that, listen, whatever steps you are taking, or you take more steps, what are those steps? And if actually you go through the status reports that were filed in the Supreme Court, one status report was filed on the 31st of March. Another status report was filed on the 7th of April. There's a huge disparity in the figures, the number of camps, on the number of NGOs who were helping out, the number of people who were provided shelter, the number of people who were provided food. It was a massive problem, and to say that, well, you do something about it, take whatever steps you feel are appropriate, and that's it. We don't want to say anything more. I think the court should have and could have gone much further. Sorry. If you look at some of the past public interest litigations, say bonded labor, for example, right? The court could very well have said, in the case of bonded labor, well, there is bonded labor, do something about it. Whatever steps you're taking is good enough. Child labor, whatever steps that you're taking, it's good enough. That's not an answer, particularly in a situation like this.
Now, let me quote you what Chief Justice Bobde said to the Hindu on Monday as his explanation for not defending what is eventually a fundamental right. His words were, "This is not a situation where declaration of rights has much priority or as much importance as in other times." Do you accept that explanation? That's his reason for saying to the government, do what you can. We're not going to put any further pressure on you.
Well, I don't want to get into anything personal with Chief Justice Bobde. It's a view that he has, and it's a different view that I have. It's nothing personal at all. So I think we should be clear about that. To say that fundamental rights are not so important today because of the prevailing situation, I think is the wrong way of looking at it. The very same argument, perhaps in slightly different words, was put forth in the ADM Jabalpur case during the emergency. And the view of the Supreme Court at that time was 4:1. Well, there's an internal emergency, fundamental rights will take a back seat. Justice H.R. Khanna said, no, they can't take a back seat. Fundamental rights are inherent. So to say that, well, fundamental rights will take a back seat, I'm not sure whether that's the correct way of looking at it.
Let's come, Justice Lokur, to the sense of priority the Supreme Court has shown in terms of what cases it's decided to hear immediately and which ones it's chosen to defer. Now, cases to do with the right of migrant labor presently stranded in shelter homes to return to their villages have been postponed till the 27th of May. Cases to do with NREGA payments to people who I presume are destitute will only be heard 2 weeks after the lockdown is over. But when Arnab Goswami petitioned the court seeking protection from multiple FIRs, he was heard in exactly 15 hours. Is that an acceptable sense of prioritization, or is it a very questionable one?
Well, Karan, it's like this. The Supreme Court issued a circular on 13th of March saying that they will take up urgent cases from 16th of March onwards. Now, what is the category of urgent cases? How do you define urgent cases, and who decides whether a case is urgent or not was not explained. A little later, sometime in April, they said that, well, it's not urgent cases, maybe on 31st of March, I'm not very sure about the date. They said extremely urgent cases will be taken up, right? Now, given the situation, I think nothing was more important than the rights of the migrants, to wanting to go back home, their shelter, their food, their wages, whether it's under NREGA or otherwise. I mean, this was of crucial importance, extreme urgency whatever word you may wish to choose. Against that, you place the case that you have mentioned about, where an FIR is filed, or maybe 10 FIRs are filed against a person. What is the urgency? The police had not even acted upon those FIRs. In a situation like this, the possibility of an arrest is almost zero, right? The police has to first, at least prima facie, verify whether the allegations made in the FIR are correct or not. And from what I have read, and even today there's a write-up on this, the petition was filed after 8 p.m. So what was the extreme urgency, and how do you define extreme urgency? Was there some extreme urgency that this guy is going to be arrested right now? And then you take it up the next day, and then you say, well, no coercive action for 3 weeks and so on. If you compare the plight of the migrants, you compare the plight of the poor as against this, there is just no comparison at all. I think it's very, very wrong on the part of the Supreme Court to have taken up that case, without it being falling in the category of extreme urgency. That's from the facts that are available as of today.
Again, in the interview that he gave the Hindu on Monday, Chief Justice Bobde defended the court's prioritization with the following argument. I'm quoting him. The courts are doing their best to cope with the situation. In particular, they are selecting and prioritizing matters they must hear. That suggests that he thinks Arnab Goswami is important, and Rega payments for the destitute or the migrant laborers stranded is not an important issue.
Well, again, I don't want to get into personalities, but I think it's pretty obvious, isn't it? That the plight of the migrants is important, Narega is important, bail petitions are important, habeas corpus petitions are important, right? As against the right of a journalist, of course, freedom of the press is important, there's no doubt about it. But an FIR which may or may not, result in anything at all, there's no possibility of an arrest. I don't see how that is of extreme urgency as compared to habeas corpus or bail or migrants or payments under Narega, the rights of the poor, the underprivileged. There's no comparison.
Let me at this point, Justice Lokur, briefly sidestep from Prashant's critique and take up something else that's closely related to what we're talking about. I'll come back to Prashant's critique in a moment's time. Sadly, this is not the first time that the Supreme Court's approach and handling of constitutional rights has been questioned or criticized. It's not the first time the Supreme Court's prioritization of matters has been criticized. It happened when the whole structure, the constitutional structure of Kashmir was changed in August last year. It happened again when the Citizenship Amendment Bill was passed by Parliament at the end of last year. Both of those raised fundamental key constitutional issues. In addition, there was also agitation and concern in the country. In both instances, the Supreme Court simply kicked the can down the road, and even now, it hasn't heard those cases. How do you explain this deliberate reluctance to hear critical cases?
Well, it's difficult to understand. These cases are very important because they have, the character of affecting a very large section of the people. Whether you're talking about Article 370, whether you're talking about the Citizenship Amendment Act, whether you're talking about migrants, huge sections of society are impacted. And really, these cases should have been taken up on a priority. I'm frankly not able to understand why that priority has not been given to these cases. Of course, it is within the court's, discretion to decide what should have priority. Whether case A should be heard first or whether case B should be heard first. Certainly, but there has to be some rational basis for deciding that case A should be heard first and not case B. Not that I don't want to hear it now, so we'll hear it on some other day. That can't be the answer.
Something else that was deeply troubling was the Supreme Court's response to a whole spate of habeas corpus petitions.
Yes.
You know better than me that habeas corpus petitions are often considered perhaps the most important petition in front of a court because it concerns the very right to life. But once again, the Supreme Court simply kicks them down the road.
Yeah, you're right. Again, habeas corpus petitions are not cases that are going to go on for 2 days or 3 days. They are based on subjective satisfaction of the detaining authority. So the scope of interference by a court, whether it's the High Court or the Supreme Court, is limited. So it's not something that's going to go on for a couple of days. I don't see why. I mean, this is a matter of extreme urgency. A person is kept in detention without a trial for months together, right? This is a case of extreme urgency, and these habeas corpus petitions, how many ever there are that are pending, they should be heard, and well, how much time is it going to take? 1 hour, 2 hours, 3 hours, maybe 1 day? Why not hear them?
Let me sum this up by putting to you what people are saying of the court, and it's been said fairly widely. People say that the Supreme Court is reluctant to take up matters that could embarrass the government, that could prove awkward for the government. Therefore, to prevent that embarrassment or difficulty for the government, it simply defers the matter. Do you share that impression?
I'm not too sure. I think the Supreme Court has a duty under the Constitution, right? It is answerable to the Constitution of India. It's not answerable to the government. No.
Then can I put this to you? Is the Supreme Court failing to fulfill its duty under the Constitution by deferring these constitutional matters, by deferring habeas corpus petitions?
Again, failing is a slightly, strong kind of word, but it should, have regard to the constitutional principles, the conventions, and certainly it should, be far more proactive than it has been. Let me put it that way.
Let's drop the word failing. Would you say it's not fulfilling its constitutional duty adequately?
Yes, adequately, yes. Yes.
Let me then at this point come to the third criticism Prashant Bhushan makes, because in a sense, it flows out of all that we're discussing. He says that the Supreme Court has adopted what he calls a hope and trust jurisprudence, placing its entire trust in the government. And therefore, he says, it's surrendered its powers of judicial review of the government's policies, directives, and actions. I know you don't approve of the word surrendered, but would you say that it is not exercising its powers of judicial review? And therefore, it's allowing the government to get away on the basis of hope and trust.
Yes, you see, the hope and trust jurisdiction goes back again to ADM Jabalpur, right, where one of the learned judges said that he has a diamond bright and a diamond hard hope that this will not happen. What happened to that diamond hard, diamond bright hope? Okay, so now this hope and trust that we are talking about today, or which Prashant seems to have mentioned, is the same in different words as diamond hard and diamond bright. So really, this hope and trust, jurisprudence, I don't think it's correct. A person has a right. If he has that right, it has to be enforced. That's it. You can't say I hope and trust that somebody will enforce that right on his behalf. This is what Justice H.R. Khanna was talking about. You may hope and trust, you may have a diamond hard, diamond bright faith or whatever, but the person has a right. Why are you not enforcing it? So, in that sense, it's, well, like you said, adequately not fulfilling its, constitutional functions.
So once again, let's drop that word surrender.
Yeah.
It's not adequately exercising its power of judicial review.
Right.
And the sad part is, this is when that power of judicial review is perhaps most needed.
Absolutely.
Not to exercise it when it's most needed is very sad and sorry.
Absolutely. Now, during the emergency, again, let's go back to the emergency. Habeas corpus, arrest without detention. Was it not most required at that point of time? It obviously was, because many of the high courts exercise that power, right? Can anybody say that, well, there's an internal emergency, so forget about the right to life? You can't. So today, there is no emergency. There's no internal emergency or any emergency of any kind. You can't say today that, let's forget about the right to life. If you can't forget about the right to life during the emergency, I don't see why you can forget about it today.
That's crystal clear. Let's take a break at that point, Justice Lokur. When I come back, I want to ask you one simple question, although I may ask it in many ways. Are you disappointed with the way the Supreme Court is functioning? But first, a message from our sponsor, Glenlivet.
Take a little trip with me, I'm gonna take you home.
Take a little history
Take a little
down this lane of memory.
down this lane.
So let's raise another glass for the glorious past and the friends we have become. Yeah, yeah, 'cause little did we know the good times come and go, but the best is yet to come.
Welcome back to a special interview for The Wire. My guest is one of India's most learned and highly thought of former Supreme Court judges, Justice Madan Lokur. Justice Lokur, I want to ask you one simple question. In part one, we talked about the manner in which the Supreme Court was not living up to its constitutional duties. It was failing to defend even the right to life of migrant citizens. It was actually exercising an almost inexplicable sense of prioritization. And finally, we even agreed that this was a time when it needed to exercise its judicial powers of judicial review, but was not doing so. So let me then ask you, in the light of all of this, are you disappointed with the way the Supreme Court is functioning?
Karan, it's like this. It's a package. The Supreme Court has got certain administrative functions. It has got certain judicial functions, right? I'm not criticizing judgments of the Supreme Court. That's for the academics to decide whether the Supreme Court has decided rightly or wrongly. But if you look at the whole package, the administrative functioning and the judicial functioning, yes, I am disappointed. You have things like appointment of judges, for example, transfer of judges, right? Listing, prioritizing of cases. If you look at the whole package, it is disappointing, certainly.
Can I ask you this? And I'm talking specifically about prioritization of cases, the listing of cases. I take it that this is a responsibility exercised by the Chief Justice as master of the roster. So if an order of Goswami petition is heard in 15 hours, but the right to life of migrant laborers is postponed to the 27th of May, this is because that was a decision taken by the Chief Justice himself. This is his prioritization that is resulting in this outcome.
I think 27th of May perhaps may be incorrect, because 27th of May, as it stands today, would be, during the vacations. So I think it's probably 27th of April, and I know that one of the cases was listed on 27th of April. But, the buck has to stop somewhere, right? Either it stops with the administration part of it, which is the Secretary General of the Supreme Court, or it stops with the Chief Justice. Now, here, I don't know. Like I said, one doesn't know what is the criteria of an urgent case. What is the criteria of an extremely urgent case? Who decides? Now, supposing, take an example. I don't know what has happened, but take an example, because the Supreme Court circular says that. There's something called a competent authority. I don't know what that means. But you want a case to be listed, you go to the competent authority, and the competent authority says, well, I don't think it's urgent, or I don't think it's extremely urgent. Then under the SOP, which has been framed by the Supreme Court, that advocate can ring up the concerned judge, the presiding judge, and explain to him what is the urgency. So I would assume that the competent authority is somebody in the registry. It could be the registrar, or it could be the Secretary General. and then the presiding judge decides whether there is extreme urgency or there is no extreme urgency. Now, in this particular case, I don't know at what level the decision was taken. Whether the registrar said, yes, I think it's extremely urgent, or whether the Secretary General said it's extremely urgent, or the presiding judge said it is extremely urgent. One doesn't know, So it's really just guesswork. But ultimately, the buck has to stop somewhere. And it would be, I think, a good idea if, the Chief Justice or the Secretary General, somebody conducts some kind of an informal inquiry to find out what went wrong. How come this jumped the queue?
You're saying something very important. We don't know who is responsible for these decisions. But as you said, the buck stops with the Chief Justice because he is the Chief Justice. And either he needs to ask questions why someone jumped the queue in this way. And if he doesn't ask those questions, then presumably he has no problem with jumping the queue. Or the other reason he's not asking questions is because he's the one who decided this queue should be jumped. The buck stops with Chief Justice Bobde.
Well, yes, in a sense, unless he has delegated that power exclusively to the Secretary General. I don't know. In which case the buck would stop with the Secretary General. But then the Secretary General would say that, well, I said it's not extremely urgent, but I was overruled. So one really doesn't know what happened. It's worth finding out.
My last question, sir. I want to quote from a recent judgment by the High Court of Malawi. Malawi, as you know, is under a state of emergency, much as India is under a state of emergency, although ours is not a formal emergency of the sort that happened in 75. But coronavirus has changed the nature of judicial functioning both in Malawi and presumably in India. And it's in that light, in that background, that I want to quote what the High Court of Malawi said in a recent judgment. The judiciary is enjoined by the Constitution to ensure that the rule of law is upheld at all times, be it before, during, or after the state of emergency has been declared. The court is perfectly entitled to inquire into the legality of measures taken by the state in response to a state of emergency. A declaration of a state of emergency does not give the state carte blanche to exercise power indiscriminately. The substantive and procedural limitations imposed by the law have to be observed. Would you have liked to have heard those or similar words spoken by the Supreme Court of India?
Yes, I would. And I may tell you, I read an article yesterday. Apparently in Nepal also, there is a problem of migrant labor. And the Supreme Court of Nepal has apparently passed some orders. I haven't seen those orders, but they have also passed some orders for the, to try and take care of the plight of migrant labor in Nepal. Well, I'm glad that, it's come out in the papers today. Perhaps the decision was taken yesterday that migrant labor has been allowed to go back to their home. Well, if it had come earlier, it would have certainly been better.
Okay.
But well, better late than never, I suppose.
But we end with an interesting situation. The Supreme Court of mighty India was not capable of standing up for the rights of its people and the constitution of its country in the way in which the Supreme Court of little Malawi has done so. We in India tend to look down on these countries, considering ourselves superior. But in this instance, the little court of Malawi, and I don't mean to be belittling when I say that, the High Court of little Malawi has perhaps shamed the Supreme Court of mighty India.
I'm not sure. If you're asking me for a comment, well, the Supreme Court of Malawi has done a good job. I believe the Supreme Court of Nepal has done a good job. The Supreme Court of India is capable of doing a good job, but I think they need to introspect. They need to, sit down, brainstorm, and figure out how to go ahead. And they're capable of doing it.
Justice Lokur, it's a very interesting choice of words you've used. They're capable of doing it. They need to live up to their capacity. That says it all. Thank you very much for speaking so openly today.
Yeah, thank you. Thank you, Karan. Yeah.
To receive instant updates on all videos from The Wire, click the subscribe button and hit the bell icon. Pay to support independent journalism. Click the link in the description and choose the amount you want to pay.